Thank you, Mr. Dunya. May I acknowledge Advocate Dunya? Siyabonga.
As the court pleases.
Mr. Dunya, you've indicated that there is an application. Is there anybody representing the media houses?
My lady, there is no representation on behalf of the media houses, mainly because the NPA indicated that there is no objection. In the light of us not objecting, in the normal course of business, then we move the application for them to be allowed to proceed with their work.
Yes, thank you. In this matter, the court does not have a substantive application on the basis that the NPA is not objecting to the ENCA and aligned partners to broadcast the proceedings. The court has also observed that this matter is of public interest and of national interest, and in the interest of justice, this court rules that the media houses, namely ENCA and its aligned partners, are permitted to broadcast the proceedings with the observance of the conditions that I believe have been discussed with the.
My lady, having dispensed with that, I will then proceed to an opening statement by the prosecution, that is the state. My lady, I would wish to hand up for the record of the said statement. Lady, at this stage, so that the court is aiding the court through.
Yes, the court orderly may take the statement. This statement will now be read, and we will designate it as an exhibit as part of the record once the prosecution has indicated their desire to do so. Yes, Mr. Dunya, proceed.
In the High Court of South Africa, KwaZulu-Natal Division, Peter Maritzburg, Inquest number 01/2024P of April 2025, before the Honorable Justice M. Radebe, in the matter of reopened inquest into the death.
MRP Easy is an effective and reliable one-stop production planning tool for small manufacturers.
I'm sitting with my colleagues that I have mentioned. My lady, as we begin these proceedings, we are reminded of what Marcus Tillis Cicero said. I quote, "Occurred before you were born is to remain always a what is worth of human life. It is woven into the life of our ancestors. The records of history. My lady, we can only part as this court joined to investigate into the death of Chief. From centuries ago remains relevant to this day. My lady of these inquest proceedings, this honorable court, South Africa, and the world shall hear of the idea from which the apartheid government operated, an ideological matrix of a South African fascist system, which considers people as homogeneous group, superior in faith, intellect, force, and in law, compared to the indigenous African people, who were considered inferior in every facet of life. Every apartheid law was made to preserve the white race, its perceived purity, perceived superiority, ensure its security. This narrative into all government entities and or the death of Chief Luthuli, the evils of this. In this reopened inquest, we shall present the apartheid government ensured that the treatment of a black man, regardless of stature, was beneath that of a human being, and of law enforcement agencies had to be protected at all costs. Evidence for your ladyship, which will a collusion between the security police, district surgeons, pathologists, prosecutor, and magistrate, including the magistrate that presided over the initial inquest on the 21st of September 1967. Before this honorable court, the state shall expose the cruelty that was meted out to those who dare oppose the ideological framework that informed the governance of a race that was deprived of its basic human rights, and the skirmishes employed to silence any opposing voice. My lady, the friends and family of Chief Luthuli, and indeed the international community, have for more than half a century been waiting to find out the truth behind his death. In the meantime, my lady, may this court kindly allow us to sketch a picture which will be ventilated by witnesses of a man whose death has brought us here today. The purpose of these proceedings is to have the 1967 inquest into the death of Chief Luthuli reopened as per the Section 17A of the Inquest Act 58 of 1959 in light of further evidence that has been uncovered. Section 17A, capital A, my lady, provides that the minister may, on the recommendations of the Attorney General concerned, at any time after the determination of an inquest, and if he deems it necessary in the interest of justice, request a judge president of a provincial division of the Supreme Court to designate any judge of the Supreme Court of South Africa to reopen that inquest. The judge thus designated shall reopen such an inquiry. My lady, a quick background into these proceedings becomes of necessity to refer to. The inquest proceedings that were held on 19 September 1967 at the Magistrates Court in Stanger in the district of Lower Tugela and presided over by Mr. C.I. Boswell. After the then attorney had declined to prosecute any person for the death of Chief Luthuli and proceeded to direct that a formal inquest be held. According to the 1967, the incident which led to the death of Chief Luthuli occurred on the 21st of July 1967, whilst on his way from his store to the sugarcane fields near Gladhow training station. It was alleged in the said record that he was struck by a train. At the end of the inquest proceedings, the magistrate concluded and found that the cause of death was, I quote, a fractured skull, cerebral hemorrhage, and contusion of the brain sustained by was struck by a goods train accidentally. The court further held that the evidence does not disclose any criminal culpability on the part of any of the employees of the South African Railway or anyone else, close quotes. The family of Luthuli did not accept this finding and have, for the past 58 years, continued to express their dissatisfaction in respect of the finding. It is submitted that the above decision by the court was not based on fact and evidence, but rather aimed at perpetrators remain hidden and protected. This is evident from a correspondence dated the 11th of September 1967, which was written about 8 days prior to the 19th September 1967, when the inquest was scheduled to commence. The said correspondence was written by Mr. C.I. Boswell, who happened to be a presiding magistrate at the said inquest. Magistrate C.I. Boswell put and communicated his opinions to the Secretary of, went to a secret circular number 2 of 4th August 67, advising as follows. I have to report that inquest proceedings in connection with the above named Albert John Luthuli will be held at Stanger by me on the 19th September 1967 at 10 o'clock. From the reports available at present, I do not expect the finding to be one other than accidental death. I gather, however, that the cause of death, as furnished by the district surgeon, might be questioned by their relatives, but I cannot anticipate on what grounds the death is based. Close quotes. This communique is from the person who would then preside over for hearing evidence. My lady, I have but to repeat that this communication predates the holding of the inquest, which was to be held on the 19th of September. And its contents indicate without a shadow of a doubt that the inquest magistrate had taken aid before hearing evidence and or conducting investigations into the death of Chief Luthuli as required by 58. My lady, an inquest is an investigatory process held in terms of the Inquest Act. The Act at establishing the cause of death of an individual who is suspected of having died of other than natural causes. Section 16 of the Inquest Act requires a magistrate inquest to investigate and record his or her findings, the identity of the deceased, date of the cause or likely cause. The magistrate must further record whether the death was brought about by any act or omission that prima facie amounts to an offense on the part of any person. The presiding officer is not called on to make a determinative finding as to the culpability. Imperfections. The magistrate has ensured that the investigation of the death of an individual is conducted thoroughly as pronounced by the court in the matter of Timol versus the magistrate of Joburg, wherein it was held. An inquest must be so thorough that the public and the interested parties are satisfied that there is and fair investigation into this. The appeal court in the Marais matter echoed the sentiments of the Timor case, wherein the court held as follows. The underlying purpose of an inquest is to promote public confidence and satisfaction, to reassure the public that all deaths from unnatural causes will receive proper attention and investigation, so that when necessary, appropriate measures can be taken to prevent similar occurrences, and so that persons responsible for such deaths may, as far as possible, be brought to justice. When the news broke of the death of Chief Albert Luthuli, many people within South Africa and internationally were deeply suspicious of the circumstances pertaining to his death. These suspicions continue for many years after his death. Many believed that the South African government of the day and its allies were responsible for the death of Chief Luthuli. Amongst those who believed that the death of Chief Luthuli was not caused by a train accident was a political activist and the founder of the 1960 Progressive Party, Mr. Christopher Rawlings. On the 2nd of July 2019, he submitted representations to the National Director of Public Prosecutions, Advocate Shamila Batowi, calling for an investigation into the death of Chief Luthuli to be reopened. The request was also supported by the then Premier of KwaZulu-Natal, Mr. Willis Mchunu. Mr. Rawlings was of the opinion that the inquest court did not take into account certain scientific and mathematical evidence in reaching the above-mentioned conclusion. The National Prosecuting Authority, together with the Directorate of Priority Crimes Investigations, launched a fresh investigation into the death of Chief Luthuli. Upon completion of investigations, the Director of Public Prosecutions in KwaZulu-Natal requested the National Director of Public Prosecution to request, as she did, the Minister of Justice and Correctional Services, Mr. Ronald Ozi Lamola, in terms of Section 17, capital letter A, in brackets 1 of the Inquest Act 58 of 1959, to have the inquest into the death of Albert John Mvumbi Luthuli on the 13th of May 2024. After considering the submissions presented to him by the National Director of Public Prosecutions, ordered that an inquest into the death of Albert John Mvumbi Luthuli be reopened. On the same date, Mola, in terms of section capital letter A in brackets 1 of the Inquest Act, approached the Honorable Judge President of the KwaZulu-Natal Division of High Court, Judge President T.P. Poyorati, to designate a judge to preside over a reopened inquest into the death of Albert John Mvumbi Luthuli. My lady, at this juncture, I wish to take the court into the inquest proceedings, September 1967. My lady, this we are doing for a proper investigation into the death of Chief Luthuli. For us to look at the evidence that was presented at the Inquest court, a court to determine how the investigation was conducted. Mary Gregerson, a medical practitioner and a super at Stanger Hospital, who in chief had to allude to what were their observations upon arrival of Chief Luthuli. In her evidence in chief, she merely confirmed an affidavit she deposed to on the 24th of July 1967 in respect of the death of Chief Luthuli, and that she at all material times was present when Mr. Joubert examined the patient. My lady, we are making this reference. The then Attorney General has made a decision that a formal inquest be held. During the inquest proceedings, instead of affidavit, whether such is in accordance with what has asked of a president, whether that is in accordance with what the Inquest Act enjoins a presiding officer to do. It is something which we will present evidence to, and later on make our submissions about its appropriateness when an investigation is being conducted. My lady, it was only during cross-examination that this witness was able to give her opinion on the cause of death. That is, that the cause of death was due to head and chest injuries. It was at this stage that the witness alluded to a fracture of which was visible, and that she believed that the patient was thrown a distance because his clothing was torn and dirty. After the evidence of this witness, the prosecutor handed an affidavit of M.J. Joubert, a neurosurgeon of Devon, which was marked as Exhibit B, as the record of the said inquest proceedings will show, my lord, my lady, as they are part of the record of these proceedings. In particular, the court might have a look at page 453, volume A. The next witness, who was equally called upon to confirm that he conducted a post-mortem examination on the body of an adult Bantu male, Albert John Luthuli, on the 21st of July 1967, and completed a report on form was asked whether from injuries he could be able to tell whether the deceased was struck from left or right. His response was, I quote, "There were multiple injuries, and it is impossible to say from which side, but I will say he was struck by some very heavy object to cause his injury." My lady, this is the least we know. From people who ought to have made in terms of the injuries as per the narrative of an accident, whether the nature of injuries accords with the said narrative that the deceased was struck by a train. As it appears on the statement, wherein we ask a question that lingers on one's mind, whether there was sufficient probing of the evidence of these witnesses about their observation of injuries, nature of the injuries, and the narrative been given. A look at the post-mortem report, together with evidence of a pathologist that is still to give evidence before this court. The court will hear of the presence of injuries on the arms and hands of the deceased. However, during the initial inquest proceedings, no questions were led as to understand how the deceased could have sustained those injuries. How could a person who is struck by a train, injuries on the arms and hands, the court will hear the classification of the said injuries as defensive injuries. And then one would then wonder whether Chief Luthuli was defending himself against a train for him to sustain the injuries on the arms and hands. Charles Baron Petrus Lewis, a detective sergeant in the South African Railway Police from Durban and investigating officer of the case, was called to read as well his affidavit he deposed to on the 3rd of August 1967, which was received in March. The same happened of Daniel Lezing-Reiling, who confirmed an affidavit that he deposed to on the 2nd of August 1967, which was later on marked Exhibit K. Peter Francois van Wyk was also called during those proceedings, and he confirmed the affidavit that he deposed to and was marked Exhibit L. Nsakani Mataba, who was working on the bridge within the vicinity of the alleged scene of an accident, was called to, and he inter alia testified that he saw the train when coming from Stanger, entering the bridge, but did not keep watching the train. As the train entered the bridge, it made a noise, but it was not blowing, rather. It was traveling very fast. From the record, no evidence was solid. Luthuli. A number of affidavits were then handed up by the prosecutor. Those, my lady, were marked, that being the affidavit of Peter Francis Papa. Exhibit B, the affidavit of Andreas Petrus Berger. Exhibit Q, an affidavit of Itich Chili. In affidavit. Exhibit S, an affidavit of N.S. Mfeka. Exhibit T, an affidavit of Zepi Gumede. My lady, Stephanus Albertus Lateran, who was the train driver that allegedly hit and caused the death of Chief Luthuli, was called to read on the 24th of July 19 to the South African Railway Police in Durban in connection with the death of a Bantu, Albert John Luthuli, marked Exhibit U. During cross-examination, after the reading of the affidavit, he told court that he first observed the deceased while he was 160 feet away from him, walking towards the train. He conceded that he did not slow down and was knocked down on the side of the engine. From the evidence that is referred to supra, can it be said that the Inquest court conducted an investigation into the death of Chief Luthuli in a manner that was so thorough that the public and interested parties were satisfied that there has been a full and fair investigation into the circumstances of the death? It is submitted a thorough investigation was not conducted at the court of court. Additional evidence will be tendered in these proceedings which may persuade the court to overturn the findings of the court of court. The prosecution will present the following evidence in persuading this honorable court to overturn the findings of the initial inquest court. We shall present the evidence of Frank Hamanyana, a member of the South African Police Service, who holds the rank of a captain, who was inter alia able to trace the inquest record of 1967 and its annexure, as well as other evidential materials he secured. To follow on his footsteps would be Colonel Madimeta Johannes Montle, who took over the investigations from Colonel Montle, secured the services of experts responsible for reconstruction and simulation of the scene. These experts, scene management section of the South African Police Service. Colonel Montle also managed to track the whereabouts of a locomotive similar to that which was said to have caused the fatal accident of Chief Luthuli. My lady, for this, the court will refer to volume B and C, which a reconstruction of the scene by Warrant Officer Brendan Craig Burgess of the National Crime Scene Management Unit. Similarly, the court will be referred to volume B and C, which relates to the simulation by Sonette Nell, who is a member of the South African Police Service attached to Local Criminal Record Center, Pretoria. My lady, to which this court will refer to, of volume B and C, relates to the locomotive similar to that which was said to have caused the fatal accident of Chief Luthuli and is in the custody of Leslie Charles Lapasrachne. Thomas Stay, member of South African Police Service, of a lieutenant colonel who was part of the initial investigating team, continued with the investigations after Colonel Montle left their unit. During his evidence, he will inter alia hand in documents that has been recovered during investigations, such as the Department of Justice files containing volumes 1, 2, 3, and 4, uplifted from the National Archives. This court, my lady, shall hear of the family This court, my lady, shall hear evidence of the family members who will inter alia test his life, harassment, and persecutions they endured at the hands of the South African security agencies. These persons are, amongst others, his surviving daughter, Dr. Albertina Luthuli, his first grandson, Mr. Mthunzi Luthuli, his daughter-in-law, Miss Velamina Mary Luthuli, as well as Zwe Mhlongo Mabaso, who was close to the Luthuli family. The Honorable Jeffrey Tamsanga Khadebe, Dr. Jabulani Mzalia, and Mr. Brian Kaba will testify about Luthuli as a teacher, an anti-apartheid activist, the President General of the African National Congress, a traditional leader, and a Nobel Peace Prize recipient. The Honorable Jeffrey Tamsanga Khadebe will inter alia testify about how Luthuli, the President General of the ANC, was persecuted like many black South Africans who were opposed to the fascist system. His 1956 arrest, along with 156 others for high treason, but was later released due to insufficient evidence to prosecute him. The numerous banning orders, which were designated to incapacitate the ANC and eliminate his influence within and outside the country, draw parallels between the death of Chief Luthuli and that of other African leaders. The state, my lady, will proceed to lead the evidence of Leslie Charles Labasrachne, a qualified steam locomotive driver and a custodian of a locomotive class 15CA, which is similar to the one alleged to have been involved in the accident which took the life of Chief Luthuli, who will inter alia this class locomotive, its features, operational capabilities, as well as probability of inflicting the type of injuries referred to in Chief Luthuli's postmortem report. Charles van Tonder, a steam boiler maker employed at Roosevelt Rail, Capital Park, will inter alia testify about how this type of a locomotive operates, starting with rail worthiness of a locomotive before it embarks on a journey, its calibration and speed. Also proffer his opinion on injuries which would likely be sustained by a person struck by the said train. Brendan Burgess, a warrant officer in the South African Police Service, stationed at the National Crime Scene Management Unit, where he is employed as a crime scene investigator and draftsman, whose scope includes videography, photography of crime scenes, forensic field work. He will testify about the reconstruction of the alleged accident scene, his findings, as well as the methodologies employed to arrive at the findings. In his evidence, he will further deal with probabilities relating to the evidence presented at the initial inquest proceedings by Mr. Latakhan, who was the train driver of the said Class 15CA locomotive that allegedly struck the deceased. This witness will further draw his findings and opinion based on mathematical calculation. This aspect enlighten this honorable. It is highly likely that Chief Luthuli was struck by a and died as a result thereof. Sunet Nel, a member of the South African Police Service, holding the rank of a warrant officer and stationed at the Facial Identification Unit at Center Pretoria as an analyst, will testify an artistic story of the scene images that were presented to her and further present her findings and or conclusions. Ms. Nell will present simulation with specific focus on inherent improbabilities contained in the evidence presented by witnesses at the initial inquest evidence. She will testify about the probable cause pertaining to injuries sustained by the deceased. Hanif Majo, a retired outpatient clerk who at the relevant time was in the employ of the Department of Health in the said capacity and was stationed at Stenger Hospital, where the deceased died after he had been admitted. This witness will inter alia testify about how he happened to meet Chief Luthuli at Stenger Hospital on the 21st of July, 1967. Contrary to the evidence that was led during the initial inquest, this witness will tell that the ambulance who drove to the scene to fetch the injured Chief Luthuli was not Peter Papaya, who at the time was a transport superintendent for ambulances, but a certain Mr. The state will further evidence of Dr. Sbuse, a chief pathologist, KwaZulu-Natal. His medical expert opinion will not only show that the injuries sustained by the deceased could not have been caused by an impact of a moving train on a human body, but it will also shed light on the inadequate treatment that was offered to the deceased to perpetuate the ideology that proper and adequate health care could only be provided to persons of European descent. This was in line with the ideological matrix of a South African fascist system, which considered white people as a homogeneous group, superior in faith, intellect, force, and in law, compared to the indigenous African people who were considered inferior in every facet of life. Dr. Nzele, in his evidence, will also draw the court's attention to contradictions in oral evidence tendered during the initial inquest and injuries recorded by the pathologist, the medico-legal examination of the deceased. The court heard that the body of Mr. Luthuli was flung following an impact with a train. However, from the post-mortem report, there were no findings on the skin of the torso or the lower limbs which could favor the notion. Dr. Nzale will further on injuries as recorded on the medical legal post-examination report, like the presence of bruises on the dorsal aspect of both the left and right hands of the deceased, as well as a fracture of the legs of the left proximal ulnar bone, which, according to defense injuries. He will also express opinion on injuries sustained by the deceased and the likelihood that such injuries were caused by a train accident. It is submitted that the evidence which the prosecution will lead during these proceedings was never placed before the court of call. Further, that the evidence presented during the said inquest proceedings was not I beg your pardon, my lady, that the evidence presented during the said inquest proceeding wait for the court to arrive at a just. It is unfortunate that none of the witnesses who testified proceedings could be traced. However, the inquest record and annexures thereto in the form of have been obtained and form part as per volume B. It is submitted that the evidence referred my lady, that had the evidence referred to super been presented to the court a call conclusion relating the death of Chief. My lady, this is the state's summary of the evidence before this honorable court, as it was presented then and will be presented during these proceedings, which we would argue at the end that there is merit in the proceedings, but also of finding that there is reason to interfere with the finding of the initial inquest court.
Mr. Junior, what is the date, by the way, of the first inquest that was held
The first
in
inquest,
1967?
Was on the 19th of September 1967. Chief Luthuli died on the 21st of July.
Yes, no, I just need the date in order to put in my ruling. I think, is that the... Do you have any further submission? Thank you.
That would be one. My lady, at this stage, I would need a guidance from court, because now I am to hand over to one of my colleagues who will start to lead.
Yes, I
oral
need to
evidence.
make a ruling in terms of section 17, capital letter A, which
the
is as
question.
follows, that the inquest into the death of Chief Albert Luthuli, held on the 19th of September 1967, is hereby reopened, and the state out to lead further evidence. And
Yes, my lady, the time now is about 12:30. I'll hand over to Advocate Siyabonga Humphrey Ngobo
yes,
to call our first state witness.
yes, I have made the ruling that the DPP may proceed, the state may proceed. I beg-
That it is reopened.
Yes, I've already made that ruling.
Thank you.
As to whether the previous inquest is set aside, that will be dealt with later.
Determined as we go.
So for the record, Advocate Siyabonga is now lead the evidence of the first.
I see it is 12:30. I do not anticipate that I will belong with the first witness, so may I call him to the stand?
Yes, call the first witness to the
I
stand.
call Khodi Samang Frank Khamanyane.
Spell it for
If
the record.
I think I've pronounced it correctly. It's Godisamang, Khodisamang.
And the surname?
Khamanyane is Kgamanyane. Did I pronounce it correctly?
Yes, my registrar will swear him in.
As the court pleases.
Sir, do you have any objection in taking the prescribed oath?
No, my lady.
Can you please state your full names?
Khodisamang Frank Khamanyane.
Sir, do you swear that the evidence you are about to give will be the truth, the whole truth, nothing but the truth? Please raise your right hand and repeat after me. I do so, help me God.
I do so, please help me God.
Sworn in, my lady.
Thank you, Mr. Ngobo.
As the court pleases, just housekeeping, my lady. I understand the witness will testify in English. However, there may well be a need for an interpreter in the isiZulu language. I understand there should be one here in court.
Yes, do we have an interpreter?
According to the stenographer, she was here, so we will pick up, but she left. I don't know why.
Mr. Ngobo,
Yes, my lady.
I understand that we were allocated an interpreter,
Yes,
but Ms. Kupega, but apparently she left the court. Can we for her to be called back into court?
as the court pleases.
Yes, we'll take a short adjournment.
As the court pleases.